Hello and welcome to Tip Tuesday on NLF Live. And guess who I have with me? Mr. Eric Toscano of Tenant Law Group in San Francisco. And Eric is here today to just give us some insight into what he does to provide justice for Bay Area tenants. So, Eric, why don't you start with telling us a little bit about yourself, how you became an attorney, where you're from, and why you decided to go into tenant law?
Okay. Thank you so much for having me on your program today. I appreciate it. It's nice to be here. I am the owner of Tenant Law Group in San Francisco. We help Bay Area tenants forced out of rent-controlled apartments get back on their feet. I've been practicing for about 9 years now, and I was born in San Jose. Grew up in the Central Valley, Merced County, and wine country, Sonoma County. Pretty much been living around the Bay Area my entire life. I got interested in tenant rights law because when I went to law school, I went to UC Davis School of Law, King Hall. They have a strong social justice, social justice oriented school. And when I got out, I wanted to do work where I would actually be representing human beings. A lot of the jobs available for fresh out of law school law students working for big firms and where your clients are big corporations. But I wanted to represent people who had problems, and so I naturally gravitated towards areas where I found that there was a need for legal services. I found that tenant rights was an underrepresented area, and I could represent individuals, and so I've been lucky to be able to find a niche and find quite a few people who needed those services.
So did you start working at a tenant rights? Well, first of all, what is tenant rights? And then did you start working at a tenant rights law firm, or did you go straight into your own practice?
All right. Yeah, so tenant rights are, I think a lot of people, when they think about what tenant rights are, they're thinking about, I'm getting evicted, I need to hire a tenant rights attorney to help me. So that is one component of what we do. That's not the main focus of our practice. What we spend most of our cases doing, if you want to think of the eviction defense, when you hire an attorney, you're getting kicked out of an apartment, so you're helping an attorney help you keep a roof over your head. So think of it as sort of like a shield, right? So we're protecting you because you're the defendant. We focus mainly on cases where, think of us as the sword, where after, in circumstances where tenants have lost their home, we'll actually go after the landlord afterwards and try to recover money damages on behalf of the displaced tenant. And there's really favorable laws in San Francisco and Oakland that make that a viable practice area for us.
So when you recover money damages, does that money go to the tenant?
Of course, yeah. So we're a plaintiff's firm, so we don't charge clients in those kinds of cases an hourly fee. We work on a contingency fee basis, which means that we can represent anyone who has a good case. And what I love about the practice areas is it allows us to represent, people who are the most vulnerable. We see a lot of recent immigrants getting taken advantage of, people with disabilities, blue-collar workers, artists, the kind of people who, again, don't have the resources to hire, pay an attorney hourly, and many of them haven't had an attorney before. I did not get my start working in a tenant rights law firm. I started working at a big firm. I did intellectual property litigation, so I was actually doing patent litigation defense. I did that for the first 2.5 years. It was a good experience to, find out about. I did learn about litigation, but I really didn't have any practical transferable skills from that to what I do now. It just helped me realize that what I really wanted to do was help out individuals, and it did confirm that I wanted to do litigation. I wanted to be in court, but I didn't want corporate clients. I wanted human beings who had problems that I could go in and fight on their behalf and get an outcome for them.
And so what are some of the difficulties that you run into with tenant rights cases?
Honestly, I think the biggest challenge is educating the public. I think a lot of people, here's a typical fact pattern that we'll experience. A group of maybe undocumented immigrants or a family of undocumented immigrants might move into an area of San Francisco or Oakland, and the landlord sort of doesn't make any repairs, and there's a lot of issues with the unit. There's cockroaches, there's no heat, there's no electricity, or just take your pick.
Mm-hmm.
And the landlord won't make repairs, and they say, we can't stay here, we can't live in these conditions, and they'll leave, and it was a rent-controlled apartment, so they're forced out. That's I mean, that fact pattern, that's exactly the kind of case that we can help someone out with. But I think a family in that situation would view, obviously, understandably, having to give up their rent controlled apartment as a loss. We have no recourse.
Right.
Well, they do. They have, there are folks like me out there who, we have, my entire staff speaks Spanish. So, we're in the process of putting up a Spanish language version website. And, we'll tell them a little bit about what we do, how we help people out, and basically what the process entails. And we don't ask for an upfront deposit. We tie our success to the success of the client's case. That's what I enjoy about doing plaintiff's work.
And we have a question a little bit tied to that. How does someone know if they are being illegally evicted?
That's a great question. So San Francisco and Oakland and a few other Bay Area cities, and it really is on a city-by-city basis, have laws known as it's referred to as just cause for eviction. So in California, generally, a landlord can evict a tenant with proper notice, either 30 or 60 days, for any non-discriminatory, non-retaliatory reason. They just have the right to, evict the tenant, find a new tenant. In San Francisco and Oakland and other cities with just cause for eviction, there has to be a specific just cause. There has to be an actual reason, an actual legal reason for a landlord to evict a tenant. And some of those, about half of them in San Francisco and Oakland, are due to the fault of the tenant, so habitual non-payment of rent. Well, it's just cause for an eviction, naturally, using it for illegal purposes, committing a nuisance or substantial interference with your neighbors. Those are all just causes, believe in both San Francisco and Oakland. Some no-fault evictions can include like an owner move-in eviction, an Ellis Act eviction, so a substantial, if there's a retrograde that needs to happen, or there's substantial a temporary capital improvement. These are all also grounds for a no-fault eviction. But in San Francisco, for example, there are relocation payments that the city says that have to be paid if someone is going to be displaced for an owner move-in eviction, and they're actually quite substantial. And again, tenants just don't know that they have these rights. So one of the things...
Okay. Sorry, is that the same thing as like cash for keys?
No, it's it's different than that because, if it's done properly and it's legitimate, an owner move-in eviction, there's no recourse for a tenant. If it's legitimate, if the owner is actually intending on moving in, then the tenant loses the tenancy, and in exchange, they are getting a payment. So I guess in a sense, it is cash for keys, but it's not, it's not technically adversarial at that point. Okay. The problem that we see is that there's a lot of fraudulent owner move-in evictions. I think the statistics I recently heard were almost 1 in 4 owner move-in evictions were fraudulent. It's just an attempt to get tenants out in order to get higher rent-paying tenants in, renters in.
Is there any recourse on the back end if you do discover that it's a fraudulent owner move-in?
Yeah, and even if all the paperwork was done correctly, if the relocation payments were made, but it turns out that the owner didn't move in, rather they put it on Craigslist, for a higher amount, or they started using it for Airbnb, they've basically broken the law, and that would be a fraudulent owner move-in eviction. Come talk to us. That's exactly the kind of case that we represent. In fact, we have a few right now where the landlord wouldn't even acknowledge that they were being forced out of the rent-controlled unit, said, no, we're not going to pay you the relocation payments, your rent's too low. Well, that's already a violation of the law. And I suspect we're watching the unit right now. It looks like it's probably going to end up being a fraudulent owner move eviction.
Are any of those violations of law criminal violations as well?
It's a great question. So one of the local statutes in San Francisco, and I believe the equivalent tenant protection ordinance here in Oakland, it's the tenant harassment. In San Francisco, it's 3710B. And it basically says that if the landlord commits any of the following acts, it constitutes harassment, and it gives rise to treble damages, including mental and emotional injury, plus attorney's fees, pretty hefty. It's also a misdemeanor. So a landlord who commits tenant harassment can be referred to the DA's office. I have never, to be clear and to be fair, I've never heard of an actual prosecution of a tenant harassment, but it's there. It's on the books as a misdemeanor. There are issues too where things can get out of hand between a landlord and a tenant. It can become violent, in which case I've experienced situations where there's the tenant will seek a restraining order against the landlord. So I have a case right now pending where it involves some domestic abuse, and there was actually a criminal protective order issued from a former co-occupant, an ex of my client, who was the recipient of the protective order.
Okay. So one of the questions I wanted to ask is, what do you do if your landlord isn't making the repairs that they're supposed to make? What are the steps that you take?
Well, the first thing I would always recommend, and we have a great video FAQ on our website of this, is you have to alert the landlord that you need these repairs made. And the most important thing to do is put it in writing, whether it's email, letter, fax, whatever, text, it doesn't matter as long as you have a record of it. And I would say, based on, be reasonable in terms of how urgent the repair is. If it's, a light bulb that's out in a back bedroom, first of all, it's probably easiest to just handle it yourself. But if it's I'm just trying to think of something, maybe an outlet that isn't working. Well, heat's pretty important in the dead of winter. That's something that should be repaired probably within a few days.
Right.
But I mean, reasonableness in terms of how quickly the repair should be made. Make the request. Our heat's not working, for example. We'd like you to send someone out. Please send someone out by this Friday. So let's say no one comes out. I'll follow up with another request. At a certain point, if a landlord's not making the repairs, and it's their job to make the repairs, something I recommend is Oakland has the Code Enforcement Division. San Francisco has the Department of Building Inspection. Contact them. Have someone come out. What they'll do is they'll send out a code inspector. Heat is a right of every tenant in the state of California, having functional heat. They'll come out, they'll notice a violation, and they'll send it to the landlord and give them a certain amount of time to make the repairs. And the repairs, usually it's, within 30 days or something like that. Now, without getting into too much of the details, there's actually a law that says if a public official comes out, issues a notice of violation to a landlord, and the landlord hasn't made the repairs in 35 days, the landlord is legally prohibited from collecting rent, demanding rent, issuing a rent increase, or issuing a 3-day notice to pay rent or quit.
And is that for how long? Until the
it's
repairs
repaired.
are made?
And then the one caveat, though, is it can't be an issue that was caused by the tenant, obviously.
Right. Okay.
So that's usually the case, is it's not caused by the tenant, but it's a really powerful law. So contacting that city official will ensure that the landlord's going to get notice of it through the city, and they're either going to take care of it, in which case problem solved, or they won't take care of it, in which case now you've got yourself a violation of this law, which we pursue claims on behalf of the violations of that law too.
Wow. So we have another question. How much can the landlord increase the rent legally each year?
So if it's a non-rent controlled jurisdiction anywhere in the state of California, it's unlimited. The landlord has a legal right to raise the rent however much he or she wants to, but they have to provide proper notice, and I believe there's a 30-day or 60-day requirement if it's above 10 or 20%. Sorry, I should know that off the top of my head. But in terms of San Francisco or Oakland or a lot of the other rent-controlled jurisdictions, it's actually set by a local rent board. So in San Francisco, I don't have it off the top of my head, but it's usually a couple percentage, like 1 or 2% or 3% a year. But it's set by a centralized rent board, and an owner is permitted to bank rent increases. So let's say if they don't increase for a couple of years, it's increased 2% one year, and then it's increased 2% another year. They can actually add them up and raise the rent 4% after a couple of years.
Okay.
So it's set by a local rent board. And just to be clear too, besides San Francisco and Oakland, San Jose also has rent control. There are several other. Mountain View just passed a rent control ordinance. Alameda, I believe, has it. There's several Bay Area cities who have rent ordinances now, and some of them were recently passed. San Francisco and Oakland's been around for a while, but some recently, and Berkeley's as well.
Okay. You provide a lot of information on your website. There's video FAQs, and you have a free legal download. Did you want to tell people how they can, contact you in the event that they have a question, or how they can get access to those free resources?
Sure. Yeah, so we have, so our website is tenantlawgroupsf.com, and there's a free downloadable report, and it's, have I been, about whether or not someone's been illegally evicted. We also have 25 video FAQs, and these were designed to answer the most common questions. What do I do if my landlord's not making repairs? What's an unlawful detainer? A lot of the most common questions we get, we put in the video FAQs, so definitely take a look at those. Also, you're free to welcome, anyone's free to contact our firm, 888-510-7511, for a complimentary case evaluation. And we just hired a client relations manager whose full-time job is it to help onboard potential new clients. His name's Cesar Gomez. And the website is tenantlawgroupsf.com. The phone number is 888-510-7511.
Okay. And what I gathered from this is that there has to be just cause for eviction, and it can't just be just cause,
Just cause, that's right.
right?
For example, we just sold the building, so you need to move out now. That's not a just cause for eviction in San Francisco or Oakland. Building
Okay.
being sold.
So thank you all for tuning in. Thank you for the questions, and thank you, Eric, for coming today.
Thanks, Rita. It's good to see you.